Science Davila. Good morning, my name is Sarah Fossoltz. I serve as the Board Administrator for the Texas State Board of Social Worker Examiners. I'd like to begin with calling the roll. Chair Brumley.
Present.
Ms. Andrade.
Present.
Ms. Della Pena.
Present.
Mr. Dollinger.
Present.
Ms. Pryor.
Here.
Thank you. Ms. Ford.
Present.
And Ms. Tatum.
Present.
And Ms. Science Davila indicated that she could not attend today. So we have a quorum, and I'll turn it over to Chair Brumley to call the meeting to order.
Okay. We will call the meeting to order at 10:05 on June 24th, 2024. This is the meeting of the Texas State Board of Social Worker Examiners. And today we have our agenda. The first item number 1 has been handled. Number 2 is presentation of staff's initial findings regarding quadrennial rule review and announcement of August 2nd, 2024 virtual town hall. All right, so is that you, Robert?
That's me.
All right, take it away.
Thank you, Chair Brumley. First thing I want to do is give y'all just a bit of an update of the process. And especially for those of the public who are in attendance and interested, I wanted to sort of let you know what the next steps are. And then I will walk through our PowerPoint that shows our initial findings. So up until this point, we have been doing sort of the front legwork, getting everything set to do rule review. We will formally announce and publish in the Texas Register rule review, probably not at the end of this week, but the end of next week, get it in the register. We as staff have gone through all of the rules, the social work board rules, as well as all the BHEC rules, and looked to see, are there anything that are old or outdated, needing updates, things that conflict with statute, things that cause any potential operational problems. And those are the initial findings that I will walk through. We've presented this to the Rules Committee and got their feedback and input. And part of today's walkthrough is to give all the rest of the board members a chance to give input. What we are looking for today is not any sort of vote or decision, but really this list is just rules that anyone thinks need attention and need to be on a list of topics to discuss going forward. For those of you out in the public watching, please see our website under the proposed rules pages. There is a little blurb about the rule review process, including a online comment form that if you would like to submit any sort of comments of rules that you think need review or need updating, very welcome, and we are eager to get your input. As the chair said, in addition, we will be having a town hall focused on social work on Friday, August 2nd. That announcement is also on our webpage on the meeting dates, and will get sent out, and a notice will get sent out with that agenda. That town hall will really just be an opportunity for any licensee or any member of the public that wants to add more feedback to us for what rules need revisiting. So that'll be a chance that the whole meeting is a chance for y'all to give input to us. After we receive that input at the town hall meeting in August, we as staff will take all of the feedback we've heard across all the boards and all the meetings and come up with a final list of the changes that we think either need to be repealed because of statutory concerns or rules that need attention going forward. And we will bring that back to you during your September board meeting. And at that board meeting, we will ask you to essentially endorse the final findings of the rule review. There's not actually a formal publication or decision point in rule review, but we would like to just go ahead and get your endorsement that yes, we've done the rule review process, and these are our findings that we're going to move forward with. At that stage, we will be asking you to propose any of the repeals, which will be, I'll point these out on the initial findings. Those will be things that do not need any consideration or amendment or language updates. They're just things that need to be struck out of the rules. So we're taking the easy ones first. After that, we will have lots of time of discussion and rule committee meetings to propose any of the other changes going forward that may need more actual consideration and development. So I want to reiterate for everybody listening that when we close out rule review in September, there is not going to be a slew of rules that you're expected to wade through and have commented on. That really is just the closing first step. And we will spend lots of time and transparent process to get public input about any rule changes going forward after that. So does anyone have any questions about the dynamics of the rulemaking process and rule review before I launch into the specific findings?
Robert, you established that Rules Committee has, y'all have done this with Rules Committee, and so now we're just getting the full board view.
Exactly.
Okay, no, I don't have any questions at this time.
Share my screen. Hopefully this will work for everything. Okay. So the initial findings that we made, we broke down into categories of things that have a sort of statutory conflict that should be repealed versus items that are just operationally we suggest would be better, and versus topics that are a broader look that we will sort of spend a lot of time thinking about. So first up, provisions needing to be repealed. In 781-306 under professional representation, there is a standard that talks about not encouraging clients to hold exaggerated ideas. And what we found is that this particular phrasing appears in a couple of the boards and is just an unenforceable standard. There's just practically speaking, it expresses a good sentiment, but we as staff cannot prove the ideas held by another person. That's just a very hard standard to prove. And in practice, instead, our investigators and our enforcement staff and our attorneys rely on the provisions that speak more clearly and directly to having false and deceptive practices and misleading clients or having unnecessary services, things like that. And so we couldn't come up with a situation where this language was ever needed. And as it's not really enforceable, we suggest that it should be just taken out. And certainly, as I go through, feel free to interrupt me with questions. 781-310 is related to billing and financial relationships, and there's a provision specifically about referring referrals and fees and using chemical dependency facilities. As the rule already says, you must comply with the Texas Health and Safety Code 164, which is generally just a restatement that you have to do that anyway. The problem is the final phrasing of the rule attempts to say that if you do comply with that chapter, then it shall not be whatever you did shall not be considered a violation of state law. We as the agency cannot make that kind of broad statement. We don't have the authority to say whether something is or is not a violation of state law. We can say something's not a violation of our rules. But in looking at this phrase, we didn't see that this rule was actually providing any meaningful distinction, because all it really says when it comes down to it is you must follow this other law that is not a law we enforce. And so we don't find any benefit. It is also already listed elsewhere in the rules that licensees must follow the laws that pertain to them, including the Health and Safety Code. So we don't think there's any particular benefit, and it actually goes a little too far. 781-313 has to do with corporations and business names. And this is one where, as an agency, we don't need to get involved in the actual, business naming of entities. That's the purview of the Secretary of State's office and is governed by the Business and Commerce Code. Really, again, this is like the first rule I talked about, where we end up, looking and enforcing is just this last sentence, an assumed name shall not be false, deceptive, or misleading. And again, that's covered in other rules. So we don't actually weigh in when someone wants to name their LLC officially something with the Secretary of State. That's not really our purview. Instead, we can rely on other rules that talk about how the licensee's conduct cannot be false or misleading or deceptive. And so this rule is just not really necessary.
So on that one, Robert, the first two, I've been doing the ethics violation since 2016 or 17. We've never had an exaggerated idea complaint. The oversteps the law, that 781.310, I don't know of one. But now this B part of this, we had a licensee who official name was her married name, but she was practicing under her maiden name. And she argued us that that was a safety component for her practice, so people couldn't find her. But we upheld that she had to connect those two names. So we're not doing away with that, or?
So what we'd be doing away with is the specifics here about how you name your business and the idea that the use of your assumed name must always be listed with the other name. A technical reading of this rule would say every time that person has a pamphlet, has a letter, has an email, they're going to have both names listed next to each other. And what
Does it have to say DBA, or that doesn't matter?
from a legal standpoint, we don't think that makes a difference, that
Okay.
it's whatever you're using your name as a corporate name is your choice. Instead, what we would want to focus on, and what we have previously focused on, is sort of what you're talking about, that instance where it's not so much that the name of the business is the problem, but that the way the person practicing has not allowed their clients to know who they are.
Okay,
And that is deceptive.
okay,
And so getting rid of this rule would allow for someone to advertise their business how they wish to, while also still keeping all the rules about advertising may not be false, misleading, or deceptive.
okay. So it would say like Caring Love Social Work, Corinna Della Pena is social work or is owner or something like that. As long as you have both of those pieces of information in one spot.
I think what we're trying to get away from is the technicalities of, are they both in one spot?
Okay,
And allow for, somebody could have a TV commercial that says Caring Love Social Work and doesn't necessarily say who. But when someone comes into the office as an initial visitation, they are presented with, here's my biography, here's who I am.
okay.
So here's my license number so you can look me up.
So making cards or advertising, we're not looking at that as much.
Not unless it is actively false or deceptive.
Okay.
We're trying to get away from bureaucratic rules that are just, you must have your name at the bottom versus is there some concern that it's misleading somebody or being false? For example, while we say you can name your business whatever you want, if someone names their business Beyonce Knowles Social Work,
Yeah,
and they're not affiliated with Beyonce Knowles at all,
that's
is deceptive.
deceptive practice.
It's
Okay.
not that it's the assumed name, it's that it's deceptive.
Okay,
That would still be regulated.
Yes.
Okay.
okay, okay.
Yes.
All right,
In 882.20, it requires the license to be issued under the full legal name of the license holder at the time that the licensure was issued. And then there's also a provision under somewhere in 882 or 884 where they have to report any change of name within 30 days to the council.
Correct.
So
okay.
You still have to be licensed under your correct name. You still have to not be false and deceptive in any sort of dealings with the client or advertising. And you still have to have some way for clients to complain to us about you with that license number.
Okay,
That's all still
there.
And to the respondent's point about safety, at one time, we published a roster with addresses and things like
Right.
that, and we no longer
Right.
display.
It just gives town and county is all you can narrow it down by.
Right.
Yeah. I
So
mean,
we have other
Yeah.
steps towards safety and that's changed in the law and in the rules in the meantime.
Okay, that's all I had on that.
Absolutely. And then the last one that we're recommending repealing is under the disciplinary actions in the enforcement rules. There's an old rule that we're no longer using regarding conditional letters of agreement. And again, not unique to this board, but it is something from the HHSC days that we don't actually have statutory authority to use. A conditional letter of agreement was akin to sending a letter telling a licensee, we think you've committed this violation and we're just telling you, you now have to go take extra ethics courses and the matter is closed. Without ever actually getting an agreement from the licensee. And that's just not how enforcement processes work now, and we don't need that anyway, because what we do now is get an agreed order with the licensee to agree, yes, you committed a violation and need to have an ethics course. Or we issue a warning telling them, here's what we think you ought to do if it's not something we care to track, because it's not serious enough.
So this is not changing our way of operation, really.
Not at
This
all. This is something we haven't used in years.
Yeah.
And it's not statutorily authorized. So there's another set of topics that are ones that we saw across all four boards and within the agency. These we don't have specific changes to discuss now, but are just topics that we will want all collectively to sit down and update. First is court-related practices. There are several rules about engagement with the court and doing things like parent facilitation or child custody evaluations. What we identified is that there are some parts of the rule in an effort to discuss how these evaluations go that went beyond the practice types of rules of what a licensee needs to do to ensure they're doing a competent evaluation, and got into things that are more the purview of the courts. Things like billing, things like when you can and cannot speak to one of the opposing parties. Ultimately, the court gets to decide who the evaluator speaks to or doesn't speak to, and how they bill and who they bill to. That's sort of outside our jurisdiction. And so
Is 781-322, is that the one where, does that have language in it, like if you're in a county that has this much population, you have to do it this way, or if you're a small county, you have to do it this way?
I think it refers back to the family code and.
Yeah,
174
yeah,
talks
I think
about
there's
that.
an exception for
For the size of the
It almost
county.
says something like you have to meet these qualifications unless it's a county that doesn't
Have enough population to have somebody, okay. And we're not doing anything with any of that.
We're not doing anything with any of them right now. This is just we want to sit down and go through them collectively and slowly to make sure we pick out what's necessary and get rid of things that overstep.
Okay.
So any change to this would come back to the Rules Committee and then the full board. Okay. Similarly, the process of issuing licenses for military service members and veterans. Mostly, we think these rules are fine. We just are very cognizant that we have different rules for different boards, and we don't want to be treating military service members or veterans differently across the boards. And so we just want to make sure they all align strictly with the provisions of Chapter 55 of the Occupations Code.
Is this coming out of that lawsuit for counseling or somebody where a school school. Oh, Daryl sent it to us last year, I think.
Yeah, but that was for TEA, I think, something related to it, but we actually amended our rule specifically to address that.
Okay.
There was federal legislation, there's a BHIC rule that was already changed too.
That fits, so now.
This
we're-
is really more just cleanup, this is
Okay.
more to polish up
Okay.
smooth out the edges.
Yeah, we don't have any specific problems in our rules related to military that we identified.
Okay,
Just-
good.
We just want to make sure we're consistent.
Okay.
And then board meetings, committees, agendas, et cetera, these are just internal operation rules that we noted. The boards have some differences in language and how they're set up. Many of these, we just want to honestly repeal to give ourselves more flexibility. They're not things that really need to be dictated by a rule, because if it's in the rule, we must do it every time. And some internal practices, they don't need to be that strict. We can decide as we go. And then other things like, for example, committees, it doesn't seem at first glance that there's a rational reason for one board to require committees have 3 members and another board require committees to have 1 member. We are open to there being reasons, and we certainly are not trying to force consistency where that doesn't need to be. But it opened up an avenue to think, we should probably sit down and talk through these and make sure those were intentional choices rather than, as things happen over time, rules just end up that way and nobody really remembers why it was that way.
Yeah, oh, yeah.
And last but not least, in this group, telepractice. This is one where our rules are just not quite as up to date as we might like because life has changed and COVID happened and we're now using a lot more telepractice and teleservices than we used to. At the very least, we want to make sure we're consistent across all of the agency with how the terminology we use for teleservices and telepractice and what we mean by when we say it is or is not allowed. Does it mean virtual face-to-face? Does it mean conference calls? Or what other services are there? Again, not sure what, if any, changes there may be, but this seems like a topic that we should take some time to really think about.
That was gonna be continually having to be looked at, it, I mean, because this is, we can't keep up with what's out there.
Right.
Okay.
Just a couple of provisions that there's no statutory problem, but just operationally, they're not quite correct, and we'd like to update as we have time. When you are talking about the supervision rules and filing an application, there is a phrase in one of these rules that talks about using the appropriate renewal form for your supervisor status. There is no renewal form for that. It's really just when you renew your license, do you pay the fee required to continue that supervision status? So we just need to, we don't want to reference a form that doesn't exist.
Yeah.
So update that language.
Creates questions.
Creates questions. And then similarly in the temporary license form, old language talking about returning the license certificate and card to the council. We don't require any sort of returning of the card. We're keeping track electronically these days. So that's just old language that doesn't make sense anymore. And then last but not least, we identified a number of just subject matter questions that we'd like to bring over time to the board to consider whether or not there ought to be any changes. And so these are ones that may be controversial and may inspire quite a lot of discussion and may not result in any changes. But once we've gotten all the repeals done and the sort of consistency fixes done, these seem to be teed up as the next topics. Things like relationships with clients. What are the necessary limits when you're talking about former clients and relatives? things like gifts, things like timelines, the sort of practice standards about how much training do you need to have, and how, when there's a violation, when you spot a violation of a fellow licensee, what is required of you, and what if it is a supervisee, what if it is a member of a license under BHEC but not your license. So again, these, I won't go through all of them now, but they're just thinking about sort of some of the tough questions that other licensees have raised to us that maybe we've identified through some of the enforcement process. We just want to make sure, are the standards set at the way the board wants them, or did they just sort of be, again, that's the way it's always been and nobody's thought about it.
Are the other three partner boards doing this as well, or have you already done this?
We have had this presentation for the counselor board,
Okay,
and then I'll give a similar presentation tomorrow with the council. And then we have scheduled meetings with psychology and MFT after the July 4th holiday.
okay. And on that 781-304, that relationship with client, are we looking at trying to align all four with the same kind of rule, or
Not
that's not
necess-
the plan?
Not necessarily.
Okay.
It is.
We lost audio.
Robert, we've lost you guys.
Good afternoon, everyone. I think we're having some technical difficulties. I think you can hear me right now. So we're working on it. We'll be back shortly. Just hang in.
Okay. Now can everybody hear us again?
Okay, I see
Okay.
Ryan shaking.
Apologies.
Yes.
Let me go back and repeat. Chair Brumley was asking on that list, there was a subject matter topics. One was 304 regarding relationships with former clients. And he was asking, is the intention to align all of the four boards? And the short answer is no, but the longer answer is it certainly gives us the opportunity, and what we'd like to do is talk about, are there good reasons that the boards are not aligned? And if not, then perhaps we should be aligned. But if there are good reasons to have different opinions, and that may include the boards simply disagree about what is the appropriate standard, you are the boards that get to decide such standards, then that is fine. But it certainly gives an opportunity to really think about how long is an appropriate time before someone who had a former client can enter into some sort of other relationship with them. whether that answer is never or some term of years. And so those are admittedly, we know hard questions and particularly to the public who's out there listening, if you have other ideas and when you give us feedback through the input form, I want to be clear, if it's an operational problem, we may act quickly, but any idea you have, I will put on that list that you saw on the last slide, and it will get considered by the rule committee. There's no idea, unless it is an illegal idea. We won't talk about those.
Yeah.
But otherwise, if you have an idea, we want to honor that and put that on the list to discuss. So that's the rule review in a nutshell where we are. Again, the link there is in the proposed rulemaking page of our website to participate, as well as the meeting dates page will have the notice for the town hall. And this PowerPoint presentation is also there. Those links there you see under the public comment is this PowerPoint's available. So any questions, any feedback, please feel free to reach out to me directly and I'll happily do my best to let you know. Mr. Chair, that's all I have.
All right, thank you, Robert, for all that information. So we have now moving on to agenda item 3, which is we've moved public comment up. So y'all have opportunity now, while it's fresh of mind there, to talk about the things that Robert just went over for us. So anybody out there that wants to make comment concerning the items that Mr. Romick has discussed are agenda items that are upcoming on today's agenda. You can do so now by raising your hand. Sarah will recognize you and you have 3 minutes. Patrick, are you timing over there? Or is Montgomery time, somebody timing? Okay. Okay, all right. Sarah?
So just to recap, we generally take people who are in the room first, and we have no public here with us. So if you are attending by computer, use the raised hand feature. Public comment is not intended for a back and forth discussion with the board, but just for you to provide your comments and concerns to the board. Please identify yourself and whether you are speaking individually or on behalf of an organization. And with that, we will start. Angie Lutz, you have comment? Can you unmute?
Yes, can you hear me now?
Yes.
Okay, perfect. I believe agenda item 8 is related to a petition for rulemaking changes that I made. So I don't know if you want me to talk about that now or when that piece comes up.
It would be now.
Now?
Yeah, now it's great.
Okay, perfect. Well, there were 3 rules that I petitioned changes on. 781.302H. I understand that the rule committee is already looking at changing this, and I'm okay with that. One of the 3 rules I wanted to address a bit further, 781.404. Section B8B, which reads, starting with number 8, council-approved supervisor who wishes to provide any form of supervision or council-ordered supervision must comply with the following. And B states a social worker may contract for supervision with written approval of the employing agency, and a copy of the approval must accompany the supervisory plan submitted to the council. My petition was to strike that last sentence. The denial letter from BHEC, when I originally proposed it, because I was under the impression it was referring to previous procedures where the plan was submitted in advance for approval by the board. We don't do that anymore. The denial clarified that that is referring to when the supervisee applies for an upgrade, that it needs to be submitted. So I appreciate that clarification, and with that logic, I think it still needs to be struck because this section refers to what the supervisor must comply with, and what needs to be included in an application is a totally separate rule. 882.1 says the responsibility for submitting a complete application resides solely on the applicant. While supervisors, part of the supervision is making sure that the LMSWs understand, they don't submit the application. And so I still request that that taken out. Thank you.
Thank you, Ms. Lutz.
And we will discuss further number 8. Thank you for that clarification.
Thank you. And I appreciate the board accepting public comment for all of these rule changes so that we don't have any surprise rule changes.
David, you have public comment?
Yes, I do. And thank you for the opportunity to bring that up. I wanted to reference agenda item number 10A. It talks about clarification regarding acceptable hours towards the 3,000 of supervised professional clinical experience. I've been an LCSW supervisor long enough to remember back before a lot of the changes that are currently in place are. And I remember what a burden it was for a lot of supervisees to try to go back to their HR departments to get specific language put in a job description that would allow that job description to be approvable under the old process. And I think it was really, so what I'm really wanting to do is advocate that we maintain our current process of having the, of allowing the management team for the supervisee to present documentation or to present a separate statement in their approval letter that says, hey, this person is going to be able to get the minimum clinical hours in their 3,000. I think that's something that's reasonable, a reasonable compromise. And I would want to maintain that current standard. I would not want to see us go back to anything more rigid that required the supervisees to have to work with their HR departments to get specific language in a job description just for them, because I think based on my experience, that's unrealistic. That's all I wanted to say. Thank you again for the opportunity to present those concerns. I appreciate it.
Thank you.
Thank you, David. Are you representing yourself or an organization?
I am representing only myself today.
Would you mind providing your last name?
It's Marsden, Marsden.
Thank you, sir. Will Francis, you have public comment?
Yes, my name is Will Francis, and I am the Executive Director of the National Association of Social Workers Texas chapter, of who I am representing. First off, I just wanted to thank Robert for that wonderful description of the PowerPoint and explaining why some of the rules were outdated, some of the concerns. I really appreciate what BHEC can do and why boards look to align certain processes, especially as they rely on shared resources. I would really encourage this board to really think about scope and how scope plays into our rules and the code of ethics. And again, as Robert said, well, just because we can align something doesn't mean we necessarily should, and especially if it's a scope space. I think that's vitally important. I really look forward to the town hall on August 2nd and the opportunity to submit comments. I just wanted to mention two rules that are up for today: 781.302 on practice and 781.401 on qualifications. In regard to the first rule, 781.302, this might be pedantic, and I apologize if so, but I know that it essentially limits the practice of an LBSW or an LMSW to an agency setting. And I just wanted to make sure that it just says the practice at an LMSW may practice. And I would just be concerned if someone had a bachelor's or a master's license, was not practicing social work, but had that and was in a consulting firm, was doing something where they independently owned. You all may feel that it's fine and it does not need further clarification, saying the practice of social work I just want to ensure that, again, someone like myself who has an LMSW who does not do social work and in any spaces where I was outside of my agency, wanted to make sure that having the license itself would not impede that. And then in the qualifications for licensure, one, I think this is a really important area to look at a change, but it is a major change. There are a whole lot of people right now pulling hours from non-clinical spaces. And I really hope that we look at what it means for current plans, especially ones that folks have already gone into. If this goes into place, what it would mean for future plans, what it would mean for others. And just really, this is something I think having a discussion with the public and really soliciting feedback on to make sure that we aren't missing things. Again, I know this does move us more towards what really is the intention of clinical hours, that they are in clinical spaces. But this is just a big major change, and just want to make sure we don't lose people on the way who've already followed the rules to get here, or that we're not pulling in folks who are really in spaces where clinical work may happen, as was stated by David in the previous comment. So I appreciate the opportunity to speak today.
Thank you, Mr. Francis.
Thank you, Will.
Kathleen Early, you have public comment? I'm sorry. Catherine Early, can you unmute? Do you have comment?
I'm so sorry, I do not.
Okay. Thank you. I see no other hands raised. And I see no one attending by telephone. So I believe that ends public comment.
All right, thank you for all those that took time out of your day to attend the meeting and comment. It is the intent of this board to be open and transparent for you, so you can have input into what the rules that impact your profession are. So with that said, we'll move on to agenda item number 4, which is board review of possible action regarding contested cases from the State Office of Administrative Hearings, including docket number 5/10/24/10/737 concerning William Swope. I will turn it over to Patrick for that.
Sure. Mr. Swope he went to SOAH. He unfortunately has a felony conviction involving the use or threat of force under the Chapter 108. It's a mandatory revocation. And so this case went to SOAH. He didn't appear. We sought a default order. SOAH granted the default order. It's now come back to the board to make a recommendation to then send it to the council's meeting tomorrow. The recommendation obviously is revocation, because that's what's required by statute and by rule. And so I think Mr. Clark might be online, that he can answer any specifics about this case, but it's a fairly straightforward one. And I think we should just look to see if Mr. Swope is in attendance and give him a few minutes to address the board if he'd like.
Sarah, will you check and see if you see a William Swope?
Mr. Swope, if you're attending, you could help me out if you use the raised hand feature. Otherwise, I'm searching by your name and I don't find a William Swope by that. I don't find an attendee by the name of William Swope.
All right.
And I do have Attorney Brian Clark, so you may unmute Mr. Clark.
Brian, do you have any input on this topic?
The only thing I would add is that Chair Brumley needs to recuse himself from the vote because he was on the ISC panel.
Oh, thank you, Brian. Yeah. Other Brian.
Yeah. All right, well, hearing that, I will entertain a motion for revocation of the license of William Swope.
And there's a proposed order for the board's consideration to recommend to the
Right.
council. If they
Yeah,
like.
it's in your packet.
Mhm.
Yeah.
Right.
So,
This is Ryan Dollinger. I'll make that motion to move forward with the revocation and submit to BHEC.
all right, we have a motion. Do I have a second?
I second.
Second by Katie. All right, all those in favor, I will be recusing myself. So all those in favor, please signify by saying aye or raising your hand. It's like it, motion carries. So it will move forward to BHEC's meeting tomorrow for final hearing or final steps in this
Consideration.
process, yeah. Okay, agenda item 5, report of agreed orders executed by the council's executive director.
Those are in your meeting materials. If you have any questions, I'll try to answer them.
Anybody, y'all had opportunity, had this a while, anybody looked it over, have any questions? All right, hearing none, seeing none, we'll move on to agenda item 6, report of cases dismissed by the council's executive director.
And that report is in your meeting materials if you have any questions.
All right, hearing none, seeing none, we'll move to number 8. So we had some public comment on this. This is discussion, possible action.
Sorry, Chair, item 7.
Oh, I'm sorry. Status report of quarterly enforcement activities. I was Xing things out too fast.
And that report was in your meeting materials if you have any questions.
All
I
right,
see none.
standing on, not seeing any hands raised, we'll move forward now to number 8. So action regarding, petition for rulemaking, Title 22 of Texas Administrative Code 881.21, including petition for changes for 781.302, 781.402, and 781.404. So, Robert, do you want?
Yeah, I can lay this out.
All right.
As Ms. Lutz, made comment, and I just want to say thank you again for sending in the petition. That's a process little used, and it is a nice way for us to get direct feedback and ideas, so appreciate you sending it in. 3 different changes we will talk about. We are addressing the substance of the change she suggests in 302 in the next item. We'll get to that. We'll just do it a little differently. But in the suggested changes to 402 and 404 were ones that we felt were the rule language was still correct. And so as staff, we already have sent her a letter denying the petition. But as tradition, we put it on the agenda in case the board disagrees with our analysis. I'm bringing that up right now. The change in 404, as she mentioned, was a rule that talks about how a supervisor may contract for supervision with another agency. So the worker is employed by an agency, but needs to get supervision by somebody else that's not employed by that agency. The rule requires that the employing agency agree to and contract with the supervisor. And what the rule states is that a copy of that approval must accompany the supervisory plan submitted to the council. The reason we require this is that when someone is submitting those hours, those experience hours to apply for a new license, a new level of license, and we can see that they are employed by an agency but supervised by someone else, we need to make sure that that agreement was reached, that contract was reached.
So to simplify this in my mind, Robert, so Corinna is seeking supervision and she works for your agency, but you don't have a LCSWS at your agency. So she goes outside to Patrick's agency, hires Patrick to do her supervision, but she's working for you. And then when she's seeking finalization of that, she gets a letter from you saying it was okay for her to use Patrick, or
Before she starts.
before she starts?
Because
Okay.
there's client confidentiality to be considered.
In that process.
In when the supervisee discusses cases with the supervisor that is not part of the agency.
Gotcha.
There's some confidentiality concerns.
Okay.
Because if I am Robert's social workers are us and private practice, I may have no problem. This is great. I need an LCSW.
Right.
If I'm the VA, maybe I have concerns or stronger feelings about who gets to look at my files.
Gotcha.
But yes, the idea is that you should enter into that agreement, that the employing agent, that I and Patrick should know about each other and agree. And that ultimately, when you are sending in the log that Patrick has signed with the hours, you should also send in the agreement that I signed to show.
To allow that to take place.
allow that to take
Okay.
place. So it sounds like Ms. Lett's point, that she made this morning is maybe this language is better placed somewhere else. And I certainly would be happy for us to look at that. I don't know that that's ripe for action. I don't know that I would suggest taking action at this moment on
Right.
that. My advice would be to continue the denial of the petition, but stating here that I will put that on my rule review list
Okay,
for us to look at placement of that language.
okay. Just
Can
to try
I-
to make it less confusing, I guess.
Yeah. just
Mr. Dollinger has a question.
Yeah, so I was gonna ask, in the past, we've always, when I was in clinical supervision, I just got a letter from the agency saying that it was okay, that I seek supervision from somewhere else. And that's what I do now with my supervisees, is get a letter to say that it's okay that they get supervision through me. I think what I take issue with is the word "a contract," because I'm not sure a letter is considered a contract.
Well,
I
the
would,
contract is with the supervisor. Do you not sign a contract of sorts with your
I've never signed,
supervisee?
no,
just
I've
do-
never,
You do the plan that's on our
yes, I
site?
do the plan, the verification, do the hours, form. And then get a letter from the agency letting them know, notifying them that, they're in supervision, but also granting permission that they're acknowledged that they're in supervision and that we'll make, disclosures in supervision. But there's no like contract per se.
So there's no document that you and the supervisee signs about how you will be paid or what you will be paid?
Yes, there is there is a contract between me and the supervisee, but not the agency. Oh,
Correct.
okay, I'm sorry, I misunderstood.
So the supervisee may contract with the supervisor
Correct,
as
okay,
long as there is an agreement with the employing agency.
I'm
If I
sorry,
said
I
that right.
misunderstood.
No, and that written approval, I think can be the letter you're describing.
Okay.
I think that would meet the terms of written approval.
Okay,
We have a raised hand with attendees. LCSW David Martin.
That spoke earlier, right?
He spoke earlier.
We'll go ahead, let him speak.
Mr. Marsden, would you like to speak? Please unmute. Try again.
Thank you again. I wanted to be sure that Angie's request was completely understood. From what I understood her saying in conversations with her, is that since there's no longer pre-approval that's required, that agreement from the agency for the outside supervision can't be submitted with that pre-approval letter. It has to be submitted now by the supervisee at the time they're applying for the upgrade in the license. I just wanted to be sure that there was clarity on that.
Yes. and
That's
that-
correct.
Yes.
That's correct. So what I believe how the rule is now, we want to make sure that both the supervisee and the supervisor understand what's required if another agency is involved. Such that, because the supervisor is responsible for the supervisee's practice, we want to make sure that all are informed at the beginning and all agreements are in place at the beginning. And then we want to see when the supervised experience is completed, we want to see that it was conducted per the conditions set in the rules. Does that help?
Yes, that sounds very appropriate, but the supervisor would not be required to send in that agreement between the outside agency and themselves until the time the upgrade is requested, correct?
Correct.
Correct,
Okay.
Yeah.
That's it.
Yeah, I
Thank you,
believe
guys.
The supervisor, correct me if anybody disagrees, but I believe the intention is it is necessary, the supervisor ought to receive that written approval, ought to be aware of that relationship,
And have it in their
and
records.
have it in their records when they are entering in that relationship. But that is for their benefit and knowledge, that ultimately, yes, when, as far as submitting anything to the council, that is on when the supervisee becomes an applicant and sends in their materials after the supervised experience is complete.
And I think his main concern is we're not going back to the pre-approval days.
Correct.
We're not doing that.
Yeah,
So,
correct.
Yeah.
Okay. Thank you, Mr. Marston.
Anything more on 402 or 404?
Not unless anyone has questions.
Anyone, board members out there, anybody here, anybody have any questions? All right, so we don't need action on these. We're gonna discuss 302 in the next agenda item. So we'll move on to item number 9, which is discussion and possible action regarding Rules Committee's May 31st, 2024 recommendation for rule change in Title 22 of Texas Administrative Code 781-302, the practice of social work, to clarify under what employment setting and supervision an LBSW and LMSW may practice, and to remove restrictions on the locations of an LBSW or LMSW may practice from, while preserving restrictions on LBSW and LMSW authorization to practice independently. Is that you again, Robert, or Patrick?
Yeah, I'm happy to present it
All right.
with the understanding that Patrick will save me if I say something wrong.
Okay.
So this change did come out of the petition from Ms. Lutz and comment from other folks. Particularly, Sarah, if you wouldn't mind scrolling down to H, that was sort of why we started the ball rolling on this rule change. H was a provision that talked about if you were not recognized for independent practice, that you were limited to providing services in certain locations. And the intention was that to just reiterate that you were not allowed to be in a fake contractual relationship where you were nominally working for an agency, but really you were opening up your own shop. You were working out of your own home. You were not under the real meaningful control of the agency you're working for. With COVID, with the change in telework and telepractice, the number of agencies that are utilizing at-home work, a very strict reading of this rule would say that these LBSWs and LMSWs, even though they were actively controlled by their employment agencies and directed to work at home virtually, could not do that, which was not the intent. And so the idea would be this language is not necessary because the rest of the rule is very clear that what's important is unless you have the authorization to practice independently, you may not practice independently. You may not open your own shop. You may not go out on your own. You must be in that employee relationship with the agency. But the other changes you see in the rule are to make sure that is very clear, that what is allowed and what is not allowed. And so just looking through in A, is just adding a specific sentence that is clear. The LBSW may only practice in an agency employment setting or under the non-clinical supervision plan per the rules that allow them. We tried to update the rule to really reference the specific provisions that offer the exception so people can find them more easily. And then similarly, changes in C are for the LMSW. That deleted sentence is just moving down to again be more clear. I will note Will Francis's comment on this rule was that the current wording is and the same actually in A, the sentence saying an LMSW may only practice in an agency employment setting. His point is, he thinks we mean may only practice social work. Obviously, somebody who holds an LMSW may have other employment and may be a lobbyist, may have a different business. We're not restricting that. And so I think we could certainly address this. I would probably suggest we go ahead and propose the rule because BHEC's meeting tomorrow and you want to get it on the books.
Right.
I think that's a non-substantive change that we can make in the
In-house.
adoption. Although I guess we could make it now.
If somebody
before-
wanted.
If any of you would like to move to make that addition, happy to do so now.
So hearing that, I would, ask that a motion be considered on, what is it, 781-302C? That the words social work be added after practice and before in an agency to clarify the type of work being done. So do I have a motion to make that change?
This is Ryan. I'll make that motion to add social work.
And would you make it for A and C?
Oh, A and
Yes.
C, sorry.
That's fine. I'll amend my motion. A and C.
A and C. Okay, so we have an amended motion to add social work to A and C prior to agency and after practice. So anyone want to make a second?
I'll second.
Have a second
Karina.
from Karina. All right, all those in favor signify by saying aye, raising your hand. So motion does carry. That change is made.
Any other, everything else is mostly just cleaning up the language. To be precise and clear.
So do we don't, this is coming out of committee. Do we need to take action on it to get it to BHEC tomorrow?
Yeah, you would need to, approve the recommendation to council to propose this change.
Okay.
And if-
So I need a motion to propose this change to the council for tomorrow's meeting.
This is Ryan Dollinger. I'll make the motion.
So a
Oh,
motion by
sorry.
Ryan,
I'll second.
that was Katie who made a second. All those in favor signify by raising your hand, saying aye. Aye. Motion does carry, so this will move forward quickly tomorrow to the BHEC agenda. All right, that takes us down to number 10, agenda item. Discussion of possible action regarding rule changes in Title 22 of the Texas Administrative Code, 781-401, qualifications for licensure, including A, May 31st Rules Committee recommendation for clarification in A1B regarding acceptable hours to count towards the 3,000 hours of supervised professional clinical practice. And B, Board's January 5th, 24 instruction to staff to accept ASWB's advanced generalist exam and satisfy the national licensure examination requirement for LMSW. April 26, 2024, board direction to refer to Rules Committee, and May 31, 2024, Rules Committee objection to rule change in A to B. All right, talk
Excellent.
about that.
Thank you. This is another one that the proposal was inspired by one thing, but it now includes more. Once we open up a rule, we find other things to fix. So briefly talking about B, this is a sentence that our staff has understood the intention to be different than the rule currently reads. And so we believed the board would want this clarification, but if we are incorrect, happy to be wrong and y'all can tell us so. This is requiring 3,000 hours of clinical experience. And yet the sentence currently reads that hours accrued in a non-clinical setting could be used to satisfy the requirements as long as you were getting 4 hours of clinical service. And so what has been happening, and we've had to allow is folks who are employed in one clinical setting may be getting at least 4 hours per week and some amount of hours, and also counting their experience in a completely different employment setting in a non-clinical setting toward those 3,000 hours. our understanding is that's probably not what you meant by getting to include other hours. And then instead, what you probably meant was that in that clinical setting, there are going to be some hours that are direct clinical services, but there are going to be other non-clinical type hours, charting and record keeping and administrative tasks, other things that are still part of that employment experience and ought to count for the 3,000 hours. So that is why we were suggesting this change.
Okay.
For the board's consideration, I recall that when I was hired in 2014, part of my training was that master social workers often have difficulty finding employment or contract with a clinical setting. But rather than preclude them from pursuing their supervised experience, they were allowed, for example, to volunteer at a clinical place and get at least those 4 clinical hours that this rule looks at. And so I'm not sure that the rule as is, before we suggested changes, is not indeed what the board intended in 2014. And part of that rationale that I recall the board members discussing was that when you are a clinical social worker, much of your day includes the non-clinical tasks, the case management, things of that nature. And of course, you would count that as part of your day. So just for the board's consideration on that.
And that certainly aligns with the public commenter, just referencing in David. Sounded like a lot of what he was mentioning. Well, he and Will Francis, I think, made Will's comment that certainly recognizing the limited nature of clinical placements. And so this change would make it more difficult to get the number of hours required overall. They would be more clinical focused hours. And so.
But that's the intent of clinical social work, right? Of the
that-
provision.
That is where we as staff will step back and defer to y'all. We had this internal debate and we need y'all to decide what is in fact the intention of those hours.
So Ron, stand in here as our clinical expert.
Hello, LCSW in the room.
Yeah.
I have a question. So I heard you say that the concern is that, hey, you're going, for example, the individual has 2 jobs, and they're using both jobs for the non-clinical hours. Is that correct? Is that one of the concerns?
Yes.
Okay. My question to you is there is a 2-year minimum requirement that you have to get. You can't get it any faster.
Correct.
So my thought process is if you worked 40 hours for 2 years, that's over 3,000 hours regardless at one place. I guess to me, it's what is the issue with having 2 places, because you can't do it any faster.
So if I'm say I live in a rural town, and my only employment in that town is doing perhaps case management for a hospital, but I'm not assessing, diagnosing, or treating in that hospital. I'm just doing the case management part.
Mm-hmm.
And that may be the wrong setting, but it was what I thought of at the top of my head. Think
Yeah,
of
you're
a
good.
non-clinical setting where a social worker is doing work in a rural town, and there's not a place for them to do assess, diagnose, and treat. So perhaps they get a private practitioner in the next town over to allow them to do teletherapy under their supervision, and they can do that 4 hours per week.
Right.
So they have to get, it's not just 2 hours of work experience, but 2 years of work experience, but 2 years of experience where you are assessing, diagnosing, and treating. And the board's previous conversation, again, way back in 2014, 2015, was that even if I am an LCSW working full-time, I'm not doing assess, diagnose, and treat my 40-hour week. There are not what they call non-clinical tasks that are incorporated into that 40-hour week. And so
Yeah.
why shouldn't that count for the master social worker who's working in a non-clinical setting 40 hours a week and either volunteering or working in a clinical setting where they can assess, diagnose, and treat at least 4 hours a week was what they came up with. And that was a long-standing policy before we put it in the rules.
In this situation, you know, with case management, you're always doing an assessment, right? And to me, that assessment is clinical social work. Because you have to have an assessment to create some type of goals and treatment plan in order to even work with the client. So I agree that there are some things that are non-clinical. I think it's going to be difficult to carve out what is clinical, what's not clinical in this particular situation. I have supervisees that are working in agencies that would qualify for supervision, but for some reason the agency is not willing to allow them to do that. And so they have to go get the 4 hours from somewhere else, even though their job would technically qualify. For example, I have a social worker that just recently contacted me to do supervision. She's assessing and diagnosing and treating suicidality through telehealth, and that's all she's doing. But the agency would not allow her to do supervision. So she has to go somewhere else to get those hours. So I guess my concern is that by taking that away from individuals, it's going to greatly reduce the ability to get supervision, but also greatly increase the amount of time that they have to be in supervision. I'm in the rules committee, right? And so listening to this proposal, absolutely, this sounds wonderful, and I agree that the scope of the supervision should be more clinical, but also taking into consideration that we are in a provider shortage, and this particular change may greatly impact someone's ability to become an independent practitioner.
And I will say we are not in a rush.
Right.
This particular item is not a thing that, so if it is inspiring more concerns and thoughts, there are other ways to address this concern too, because to your point, maybe you do want to allow someone that alternative setting to work in their primary role, but go to another job and get the 4 hours per month, or per week. But 4 hours per week for 24 months gets you roughly 384 clinical hours. If you were pursuing that, maybe y'all want to consider how many direct of the 3,000, how many must be direct clinical services. And so that maybe that person, maybe that's
Sort of like we do where they have to have 100 direct supervision hours, they would have to have some number of direct.
exactly. And so maybe if that 384 sounds sufficient, and then that's great. Then we don't even need to change anything. But perhaps y'all want to take some time and we can consider what is the 3,000 still the appropriate number? Is the 24 months still the appropriate number? Is there some amount that needs to be clearly direct, but less than that 3,000?
Ryan, would sending this back to Rules Committee and asking for community public input to come in, I don't, where could it come into?
We could do a town hall for it if you like.
Mhm.
We did
Okay.
that with like the field instructors, we did that.
We did that field
Mhm.
instructor, we could do it maybe
I'd
a
l-
town hall and have this back on the agenda. What are we coming back in
Mhm.
October?
September
September? Okay,
Um,
so we
I
could,
will say we're already having a town hall for the
August
rural
second,
review.
yeah.
Yeah, so perhaps we can,
Can incorporate this into that.
I didn't want to assume you wanted to share.
Yeah.
But it is rules.
but
Yeah.
and I don't know that I have capacity for another town hall.
Okay.
So,
Well, let's keep
I like-
this.
I like the
let's just-
idea.
Oh, somebody's talking.
That
Mr.
was me,
Collins.
sorry.
Oh.
I was just gonna say, I like that idea. You know, it allows the public to comment and the people that this is really gonna affect to comment.
Mr. Francis.
We'll take a short input from Will Francis.
Mr. Francis, can you unmute?
Yes, this is Will Francis with NASW Texas. Thank you for just giving me a brief moment. I really appreciate you all pulling this down. This has been a very confusing rule for me. I get a lot of questions about it. You know, say here I am in LMSW, say I want to go get my clinical hours. Could I count my hours here at NASW as part of that larger 3,000 if I was working 4 hours somewhere else? That to me feels ethically not right, that nothing I do here is connected to really the practice of social work. And yet the rule feels big enough to potentially incorporate that. I'm not positive that the language as proposed today is the right answer. So coming to a town hall is perfect. I love doing it on second, but if you do need any opportunities, I would just offer our services as a space to support any town halls, discussions, feedback, or other things. But we get so many questions about this specific rule, and I do want to thank you guys for looking at it.
So let's do that. Let's just table this for now. Ask that it be put into the August 2nd town hall. And if NASW wants to do also something on their side and get public comment, reach out to their folks and send it to us. We'd appreciate that. And then the Rules Committee can meet after August 2nd, but before our September meeting, and have us maybe some rough language that we can discuss at that point. Does that sound fair to everybody? Okay, all right,
so
Robert.
that was just part one of that.
Yes.
Do we need a motion to table that or just general consent is,
General consensus, but you're not acting on it, so
okay.
it's just not
Just wanted
moving
to
forward.
check.
That's fine.
So, cause that was part B that you did first, but yeah.
A.
That was it.
Oh,
That was
that was
part
A,
A.
okay.
And so part B, is proposing adding the advanced generalist examination to the authorized exams to take to become an LMSW. And here, we have a bit of a, conflict between the direction we've been given, and so that's why it's here. Members of the Rule Committee did not recommend proposing this rule to the board. However, previously, the board has directed us to recognize that exam and start authorizing it. And so as we're currently situated, our practice is not matching our rules. And so one of them, we do need an affirmative decision by the board today to either allow the advanced generalist examination and propose it in the rule, or to rescind that direction and have us no longer recognize that examination.
So Rules Committee, what was y'all's issue with this?
Yeah, so Ms. Science Davila had, and she's not here, I hate that, but she mentioned that there were several people that she was aware of that had taken this advanced generalist exam and had difficulty later on in clinical settings and to being able to provide clinical interventions. And then also we looked at the ASWB website comparing the two, and the generalist exam is what it says is a generalist type of license, whereas the LMSW exam had some aspects of clinical interventions. And so we felt like the LMSW exam was more, I don't want to say rigorous, but It felt like it was more encompassing of what social work is, as compared to just a generalist exam. A generalist exam would be more like, for example, if they wanted to go work at NESW in like a macro setting, whereas the LMSW exam would be for all micro, meso, and macro. And so our issue with that was that we didn't feel like the generalist exam covered enough information.
So help me understand here, Patrick or Robert, then. So let's say we have somebody, because in Texas, we no longer do the AP, which that exam would give you. I mean, we still have some of them, I guess.
Yes.
People that exist because they got it. Other states use it. We don't use it, correct? We
do not issue the advanced
AP
practitioner
certificate or
specialty
license.
recognition.
Specialty recognition, okay. So, but other states do. So if a person who had that somebody from, let's just pick Nebraska, I don't know if they do or not, but say they moved to Texas and they're LMSW AP, we still have the ability to honor that here, right? They could get a Texas license that matched the Nebraska license.
Under current rule, they would apply for the Texas Master Social Worker license.
Okay,
And they must, under current rule, they must have a passing score on the master's exam. Under current instruction by the board, staff would accept, since January, staff would accept the advanced generalist passing score.
But we wouldn't
we-
issue them the
but-
AP.
But we don't award them the specialty recognition,
Okay.
only the LMSW.
so we don't do that AP, that recognition to anybody anymore.
No new ones,
No
only,
new ones, only
only
those
as
that exist.
Patrick called it, legacy ones.
Okay.
So if they've already had it in 2017, when we stopped issuing, we didn't take it away from
Right.
anyone. And as long as they continue to renew, they're fine.
But to
But
that point,
our operations and our rules need to match.
yeah, we do need a match, and so unless the rule changes, unless you propose the advanced generalist exam going forward, anyone who is licensed in another jurisdiction for 1 to 50 years
Yeah,
that took that exam, when they come here, they would have to take the master's exam. We could not recognize that exam.
and what is that gonna do to us if we get this portability thing?
It's
compact?
Compact, yeah.
It does limit portability. It is, the more options people have, the more portability there is.
Okay,
Certainly, it is the problematic nature of having a license that is so broad in the walks of life that your licensees can do.
yeah,
If there are two philosophical approaches. One is, as Mr. Dollinger is describing, having a sort of like the bar exam for lawyers. Everyone must know a little bit about everything before you're allowed to practice, under the theory that, well, you could theoretically
get that.
do anything. The other theory is more on the enforcement side, which is to say, well, you are only authorized to practice what you are trained to practice. And so the answer to the folks who had trouble shifting into clinical would be
Right.
saying, well, if you took the advanced generalist exam and you were trained as a generalist, yes, you have a license, but you're not authorized to do something you don't know anything about.
Right, it's outside your scope.
Unlike attorneys, admittedly, is one of them, we have a little more flexibility to wade into waters we're not necessarily competent at. Which
But
is
we
not
also
necessarily
have,
good.
we also have in rule that you shouldn't practice outside your scope.
Correct.
So that's there.
But this came about exactly from your scenario that you said, somebody's been licensed in good standing for 20 years in
Yeah.
another state, wanted to get licensed here, and we
had to tell
instead
them
of,
no.
until we got the policy from the board that said we can accept their passing score on the
Yeah.
AP.
And if we just left it like that, but didn't allow people in Texas, we'd have a sort of two-tiered system.
Yeah, there would be a
We could
different
take-
treatment, and we'd be
we
treating,
can't, we don't need to do
we'd be
that.
treating Texans worse than we would
Yeah.
out of state people.
All right, so hearing all that, what do y'all think?
The recommendation from the Rules Committee was that we grandfather the people since January who have been allowed to get their license with the generalist exam and to continue on with just the LMS, the master's level exam.
Okay, so, that coming from committee, does it need a motion still?
So, yes, we would need y'all essentially to affirmatively rescind your directive to us to
Okay.
accept. Just for clarity and transparency, we probably should have an affirmative vote one way or the other
Okay,
of the full board.
okay,
So the board can either vote to agree with Rules Committee and rescind the direction. And so we would not allow folks coming in with the advanced generalist, or you are fully authorized to disagree with the Rules Committee and someone can make a motion to propose this rule minus the part we already struck out.
okay. All right, so we are at that point now where I need a motion, so.
This is Ryan Dollinger. I'll make a motion that we go forward with the Rules Committee recommendation.
Okay, and that rules committee recommendation would be to grandfather those from January until today's date, I guess.
Mhm.
That those applications are accepted. And from this date forward, they would be required to sit for the LMSW exam.
Right.
All right, so I have a motion from Ryan,
I'll second.
have a second from Katie. All those in favor signify by raising your hand or saying aye. 2, 3, 4, 5. She voted yes. So, anybody voting in the negative? Seeing none, anybody abstain? I will officially abstain. All right, so the motion does carry. So the direction to the staff has been rescinded as of today's date. Now, just for my general information, how many of those do we get a year?
To my knowledge, and I don't track that.
Right.
But anecdotally, there are a few,
Okay, so we're not 10, not 100.
not 100.
Okay. All right, so that completes agenda item number 10. We will now move on to agenda item number 11, board review and possible action concerning quarterly summary from the Texas State Board of Social Worker Examiners Jurisprudence Exam Vendor. That is, I know is in your packet because I saw it.
Yes, so if you have any questions or comments about the jurisprudence exam report, I'll be happy to try to address those.
And it's just information. So yeah, if
Yeah.
there's anything, we're not making any changes. I guess if some of these rule changes that Robert presented to us do change in the future, we will have to consider going in and updating in the
And-
jurisprudence.
And
so
from
forth.
from the last board meeting in April,
Uh-huh.
I do have some questions for the Professional Development Committee.
Okay,
We set a tentative date of July 11th, and I haven't followed through yet with the Professional Development Committee members, so after today's meeting, I'll follow through with
Okay.
that and see if we can get that set. So
Set
there
up.
may be changes to the exam coming forward, but not based on a rule change.
and for the public out there, that's just, we do our best to try to keep the jurisprudence exam aligned with changes that we make, so that when you are taking that exam, it is the most current rule that you're looking at, so. All right, there's number 11. Number 12, report from board chair concerning current challenges, accomplishments, lawsuits, interaction with stakeholders, state officials, committee appointments, functions, workload, board members, conferences, routine functioning of the board. I will say, I did attend the ASWB Regulatory Education and Leadership Conference back in April, I think it was. And from that, just to let you know that ASWB is currently working with CSWE and NASW in coordination, working on exam issues that have been brought up in the past. ASWB staff are taking care of the folks those of us here in Texas when you apply for your new license or some change in licensure status. You go through their process. I did interact with them quite a bit to see what kind of feedback was there, and so far it seems fairly positive that the timeframes that it's taking people to get through that process to get licensed is much shorter than it was several years ago. So that's been a benefit to both the state of Texas and the applicants here getting them licensed faster. Other things that's happening, the compact has officially hit its 7th state. I don't know, it may be more than that now, but and I did see an email concerning Texas that there has been discussion from some folks in the legislative area, some representatives, senators, whatever, have started asking questions. So look forward to the 2025 session when they start entering bills that Texas will be considering also looking at it. Sarah's, so all those in blue. So there's way more than 10 now.
The dark blue.
The dark blue, yeah, the light blue, it's pending. So all those in blue on your screen, the dark blue, the compact is in force. And those little light blue, powder blue ones are coming soon, and those gray ones are to be determined. So that's all I have on that report. I guess there's, I mean, if you're planning, NASW is in November this year. I think it's going to be in Irving, if I remember correctly. So, all right, that takes us to 13, Board Administrator. So, Sarah, you want to give us a report on anything you got going?
So I included in the board members' materials, the third quarter performance measures. They will be presented to the council tomorrow, so I don't know much about them except that they were hot off the press and I put them into your materials. So
Okay.
if you have questions on that, I'll be able to answer them after tomorrow. And also in your materials, I presented to some social workers at the Department of State Health Services, Specialized Health and Social Services at their training conference on June 13th. I haven't yet received those presentation evaluations, but I will share that with the board as soon as I get them. They were a very gracious crowd, so I'm hoping for good evaluations.
Good job.
And I attended the June 6th Texas Statewide Health Coordinating Council. My notes are in your meeting materials. I don't think there's anything particular to call out to you in that, but it's just for your information. I've had a number of inquiries from those who are educators or a field instructor, and then from some people who are exam candidates for the ASWB exam. They're having some difficulty trying to get their exam registration done, and I just wanted to show on this is our homepage. If you click on the masthead on Texas State Board of Social Worker Examiners, and then slide down to the bottom of the quick links, the ASWB licensure examinations, you'll click there to register for the exam. That big black button in the middle is the link to the online registration at ASWB, specifically set up for Texas. If you have any difficulty, please email the ASWB staff that are familiar with Texas processes at texas@aswb.org. If you call us, we'll refer you to ASWB. If you call ASWB's general hotline or general email, they'll refer you back to us and you'll be in limbo. So please contact the staff at ASWB who know about Texas. We are one of a few states who contract with ASWB for pre-exam eligibility tasks. And so their general hotline call center staff answer the questions that you ask for the other 46 states. So, so again, contact the people who know about that.
You can also go to aswb.org/Texas and it'll take you directly into that.
Okay.
So,
Good to know. So, also before you call or before you send an email, we have a lot of information on our how-to user guides webpage, and that's again in the right-hand side on the quick links. Anything that you need to do with an online transaction with our database, there's a step-by-step instruction with screenshots and explanations there in those how-to guides. I'm clicking again in the masthead for Texas State Board of Social Worker Examiners to get the quick links for the frequently asked questions that is specific to social workers. So click on the masthead social workers first, and then the quick links FAQs. Many of the situations that we get inquiries about are described here in these frequently asked questions and the answers that pertain to them. That may save you some time waiting for staff to reply to your phone call or to your email. I think that's it. I showed earlier when Deputy Executive Director Romig was speaking, our proposed rules changes and the rulemaking process, where we have information about the quadrennial rule review, and there is a link there to submit your public comment. If you want to submit it in writing, please do join us on August 2nd for the town hall. And as he noted, I'm clicking on social workers and then clicking on the meeting dates. And as he noted, we have information up for the August 2nd town hall. We've got an announcement, and the initial staff findings is where you can find that PowerPoint. We welcome your comments.
and that's the PowerPoint Robert had earlier.
Yeah.
Yeah.
So, one more thing I'd like to mention, ASWB launched the social work census in March. They extended the deadline for responding to that census until June 30th, 2024. So if you haven't responded to that census, or your colleagues or your friends, please have them respond, so that can be as robust a census as possible. The social work, as we mentioned, the council meets tomorrow on June 25th. This board meets again on September 13th. And that concludes my report unless there's any questions.
All right, Robert, Patrick, anything from y'all about the workings, the goings on? I know we've been doing hearings, informal settlement conferences fairly regularly. We don't have any scheduled right now, so I don't know, maybe things are y'all whittling through them. We don't have that many, or?
No, I mean, they're still going through, but I'm sure they come in waves. So
Okay.
I'm sure there'll be more coming
Okay.
away soon
It
enough.
rains at 4.
Yeah, I hear you.
I think we are, you'll hear tomorrow, but we're very happy. All of the oldest complaints have been resolved.
Good.
And so we are only working with cases over the last 2 or 3 fiscal years.
And then, Sarah, one of the questions that I get, and I know you can show folks there if you don't mind, where Tim Spear keeps up with the how quickly applications are being completed. He's got that flow chart on the website. I direct people to it. So folks, if you're out there, if you know somebody who's, looking at when their license may actually be granted after they've done the test, they've done the ASWB, they've done the application, how long? So it's that applying for a license and timelines. You click there, and you scroll down, and there it is. So you look in the middle under social work. So, today they're completing those that they received June 8th. So we're what, two weeks, basically. 14, yeah, right at 2 weeks from the point they get it until that license is complete. Now, those are
Oh.
ones.
So I need to,
Yeah.
so what happens is staff has looked at applications that were received on or before June 8th. That doesn't mean that they approved the license. It means that they looked at it and they sent a deficiency notice. Or if everything was there, they approved the license. So if that's past the date, then you might need to be looking for a deficiency notice. And again, check if you're looking for messages from staff, then please check your spam and your junk folders, because oftentimes our government email gets routed by the recipient's email platform into junk or spam. And also, there may be some items that some things come in by the mail, some things come in by email, some things come from another state agency or from the National Practitioner Data Bank. And so those things need to be gathered. In order to keep within 2 weeks of looking at things as they come in, we ask that you not send a request for, hey, did you get it? I sent it 10 minutes ago, or hey, did you get it? I sent it yesterday. Because staff, the same staff that look at the application, are also answering the phones and responding to emails. So the more calls that we get, or the more contacts that we get asking, did we get it yet? Or what's the status? The less time staff has to actually review the applications. So staff does ask that you wait at least 6 weeks before you start asking about status. Oftentimes they will send that deficiency notice or issue the license well before that 6 weeks. But we're just trying to keep that call volume down and that email volume down with those things that we're not going to be able to provide you with an adequate answer, and that just take our time. Is that
That's
where you wanted to
exactly,
go?
yes, because I would tell people all the time, this is not a don't call us, we'll call you situation. It's all the information has to converge in a single place here in Austin before they can issue that license. And so your fingerprints are coming from one place, your test scores coming from another place, the National Provider Data Bank's coming from another place. Your transcript was sent up to ASWB. All that has to come together. So it's not simply just sending in that one. A lot of people have the mindset that when they send that application, that click, it happens. But it's all the other pieces of that puzzle have to be fully complete before the license can be issued.
And please know, if you sent it to ASWB to be approved to sit for the exam, ASWB does not send it to us. So we are two separate agencies. So if staff is asking for it, it's because they need it. And don't assume that ASWB is forwarding it to you. I also wanted to bring to your attention this chart at the closer to the bottom of that same page. We report our minimum, maximum, median, and average timeframes for each license type for the previous fiscal year. And so you can see the median number of days, for example, for a master's application is 16. The average number is 27. That might give you a little more comfort of when you need to be checking your spam and your junk email for response by staff. I hope that's helpful to everyone.
All right, anything else? Any questions, any input from any of the board members before we wrap up today? Anything? Nothing? All right, seeing none, hearing none, I will entertain a motion to adjourn.
I motion.
Have a motion from Karina, have a second from somebody.
I'll second.
All right, Katie, you got it. So all those in favor, please signify by leaving the Zoom. See y'all next week or next month, whenever. Yeah, sometime in the future. Thank y'all.
Thank you.